Sanwanani, hello, hello. Dokotela, sawubona. Hey, Xoli. Benedict, I see you. Good afternoon. Paul, how's it? Welcome. Hey, Putipaka, Orinchaka, welcome. Xoli, Bongani, how are you? Welcome. Mr. Matabuhe, sir. I hope you're well and you had a good day. Welcome. Hey, Tsuho, welcome. Thanks for joining. Okay. There you go. Okay. The head will close. Mr. Mkwen, I'm well, man. It's just busy. COVID-19 is keeping me busy from a work perspective. Conference call back and forth. Mr. Makapane, our guest, has just waved and said hi. Tando, hi, how are you? Dumzaza, good evening. Oli, I see you. Vanessa, hello. TD. All right, we're just going to give Lindy, how you doing? Just a few people a bit of time to join in, and we will then start in a few minutes. Masadi, hello. Tati. I'm all good, just a little tired, but it's the nature of the beast. But overall, I am happy and looking forward to what will happen if we do go to level 3. Didn't Claire, I see you. Hi, Arnold. Welcome. Emily, how are you? Tati, Tanda, Sanborani. I am trying to keep up with as many people coming in. So, Reggie, I see you. Keke as well. Maybe in the next minute or so. Sure, a lot of you are joining. Thank you. Welcome. How are you guys today? How are you feeling? How's this week been? Has it been kind? Tabisolo Olancha. Okay, so there's 25 people that have joined. That makes it 26. With Bongenkile Tau has joined, so we're looking at almost 30 people or so. I think with the power vested in me, we might just reach a quorum. So let's see. A few other people are joining. Welcome, everyone. Our guest will be joining us shortly. In fact, he is here. He's just going to send through a request shortly, and then we'll be ready to go. Welcome, welcome, welcome. Hey, Shinaz, please send my regards to Rashad. Hope you and the kids are doing well. Thanks for joining. Malibonge, welcome together with Calvin. Hey, Fiona, welcome. A lot of you will probably remember Fiona from our live Instagram session last week. Hey, pal, welcome. Thank you. Oscar, I see you. Okay. Thanks for joining, guys. I really appreciate it. There you go. Loads of Instagram. You press a button and suddenly it just changes. I wonder if it was an issue. Hey, Swoo, how's it? Welcome. Our guest is also joining. He's actually here, so he's about to press the live button. Please bear with us. There you go. Yes. He just sent the request. We are going live now. Okay. He should be accepting and we'll be live. There you go. Yeah. Mr. Makapane, sir, how are you? Apparently, I need to lift up my face. I'm well, how are you?
I think I also can't see you very well.
Okay. Is this okay?
We can see up to just above your eyes. We know you want to show off your beard, but some other time.
I'm really trying, guys. Just bear with me. This is the second live session that I'm doing. So let's see. Is this okay? Can you see me?
I think that's fine. Yeah.
Yeah, we'll live. I mean, these things do happen. And once in a while, I will always just press, just say a few things and note people. But welcome, Khomotso, and I really appreciate you taking time and, chatting to me and the rest of the people who've joined. I was just saying earlier, hey, pal, that, I think we've definitely reached the quorum. This is one of those live sessions where we have more people. So I'm quite happy. And I think, true to your other functions as an acting judge, we're asking that you open these proceedings formally.
No, I think it is an honor and a privilege to have. I think when you called me to be part of these sessions, I was moved and I couldn't say no, because I think it is important that as people, particularly during these times, that we can share as much information as we know, because it might go a long way to help people. So thank you for. Yeah.
No, it's my pleasure to host you. I mean, so how these IG sessions came about, it was on Mother's Day last week, Sunday, and it was 11 p.m. And I've never done an IG session live, in fact, last week rather. And I clicked, and some people were online and they subsequently joined. And we just started having casual chats with a few. Some of them are here. And, I just saw that there is an interest, and I asked people what they're up to and what is it that they'd like to see. So last week, I had a chat with Fiona, who's also part of this discussion. She spoke about mental health, the changing world of employment and stuff like that. And I think because of the interest and what people are looking at and what I normally see on the timeline, it's now becoming clearer that ours is not just only tweeting, but also just sharing and imparting information. So really, this is more of a information sharing session. More importantly, we are basically doing our contributing so far as informing people. People ordinarily would pay for these type of sessions, whereas if you just have data and you're here, this is, in my view, and I'm hoping it's going to go a long way and stuff. But without wasting time, I'm just going to do a brief introduction of Khomotso. His CV goes to the to my floor, but Khomotso really is a good friend of mine. That's my former colleague and my senior at ENS, and we worked together for some time. Interestingly, he also worked at the labor court where I worked as well. So I keep following him around, and I'm hoping I'm not going to end up back at practice as well. But Khomotso is a partner at Bowman's. This is one of the top firms in Africa. In fact, it has a global footprint, and he's a partner, an executive there. He also is an executive coach and assists, executives to really unleash their abilities and stuff. He mentors kids in and around Johannesburg and Limpopo in particular. And for his sins, he's also an acting judge at the labor court at times. So I will try by all means, Khomotso, not to be contemptuous at times, and just make this conversation more exciting. So that's the purpose. We are going to try to make sure that we do not be more legalistic. We want people to listen to this and take the information and be in a position to share these chats, because I'll then save it, share the link with you. You can house it wherever you want to house it. But the point is, it's an information sharing. It's quite informal. We'll take questions. In fact, I'd like to say thank you to people who sent through their questions. We have over 2 pages of questions. So those are some of the things that we're going to deal with. So that's part of the introduction. And how I think we would probably want to deal with as well is we would look at the relationship between the employer and the employee. What is this relationship? Does it even exist? And what is the basis of the relationship? Is shaking of the hand one, way of saying there's an employment relationship? Does it have to be reduced to writing, for example? And what are the legal consequences? We will then move to the answers that were sent through Twitter, WhatsApp, and DM, and just attempt to answer those. Some of these questions are repeating, and we'll just say, please, consider where we looked at and where we've addressed it. The benefit with these type of sessions is after it's done, you're able to rewind and start all over, and then we'll just do our closing remarks. So that's really the structure. And if you're happy with it, Mr. Makapane, do let me know, and then we can shoot right ahead.
I think I'm in your hands. I'm a guest in your house, so I'm happy to play by those rules. Yeah.
All right, thanks a lot. I think we have an understanding. So what we're seeing, as I said, COVID is basically an unknown. It has taken not only South Africa, but various economies by storm. And as a result of that, we're seeing, a move in economies where people are either being retrenched or being let go. We're finding companies trying to stay afloat and coming up with new innovative ways of surviving and ensuring that when they go forward, they will be able to get out of this pandemic, above the rest. And it's also about competition at the end of the day. But for someone who is currently working and one is worried as an employee, what is this relationship? Does it still exist, the relationship between an employer and employee during COVID-19? And I ask this because some employees are working at home. We will talk about some of those expectations, that if you're outside of the office, are you still considered an employee? And the terms and conditions that bound you would still bind you as you are sitting. So if you could please talk about the relationship between an employer and employee from a general perspective, and we can just talk about what forms this relationship.
Thank you, Tumi. It's unfortunate the topic we're talking about is not sexy by any means. So if people could just wave and send whatever they can just to inspire us in this code. But I guess maybe there's a starting point, as you say. So the basis of an employment relationship is a contract, an agreement between the employer and the employee. And it is important that we speak about this before we go to answering the questions, because a lot of the questions we're going to refer back to the employment relationship or to the employment contract. So I just want to deviate a bit and say this. At the rush and excitement of getting employment and starting, often we don't pay particular attention to the employment contract when it is handed to us. When we get the employment contract, we read quickly or we skim through it, and we go to where it matters. Annexure A, where the remuneration is set up and stuff. So we don't often look at the other granular terms. But I think just to simplify it is important that we always are mindful of what is contained in the agreement that the employee has with the employer. And I guess, again, what I'm going to say is this, as an opening remark from me. We are experiencing times that are unimaginable. So no one could have imagined these times a few months ago. And therefore, when we speak about the law today and the consequences and so on, we need to understand that we need more the human element. We need to consider the human element, both from the employer's perspective and also from the employee. Because if we're going to talk strictly about the law and to talk about contracts and terms, we're going to miss the times we're in, and an opportunity we have as humankind to actually work together, to find a way to work together, to find solutions together, rather than to work against each other. So against that background, I think I agree with the initial comments you made about the state of the economies and so on. And the answer is yes. Even if you're working away from home, working from home away from the office, you are still governed by the employment contract. That employment contract may need some adjustment should this continue in the long term to also cover remote working. Because when we entered into these contracts, we did not foresee remote working, and therefore we hadn't, prepared for conditions that will govern people when they work from home. Like, do you actually have to start at 9? If your employment contract said you start at 9, do you have to finish at 4, at 5? How do you work at the same time, be a mother or be a father? You know, all those kind of things.
Yeah, no, definitely. So, and I think we are aligned that it requires creativity. But, you know, it's always difficult to have an employer and employee agreeing on certain things. You know, conference calls happen at any minute. You know, we are lucky now that we're having this discussion. The likelihood is your overseas client, it's 12 p.m. in Australia, for example, and they maybe want to chat now. You know, how do you adjust that? And I think Fiona gave tips last week when we spoke about this to say, how do you start introducing those type of discussions and stuff? But, you know, there are certain things that we are seeing as well in terms of these employment contracts. People are coming up with so many things to say, my terms and conditions have been changed, you know, and I don't understand why is this happening and stuff like that. You started by saying an employment contract is, you know, sort of an agreement between an employer and an employee. And as I assume it, you'd have to have agreement and stuff like that. But maybe just speak in general of these terms and conditions, and ordinarily, you know, can they be changed willy-nilly? And if they can, who can change them, and what ordinarily happens in these circumstances?
The simple answer to me is you can't change an agreement unilaterally. So meaning one party to the contract can't change that contract on their own. They need the consent of the other party. So an employment contract ordinarily will be in writing, will be reduced into writing. If it is not in writing, the terms will be clear between the parties. And whatever has been agreed, the one party to the contract, either the employer or the employee, can't change them without the consent of the other party.
All right. And I think that's very important, because people wake up, they go in due to COVID, and sometimes employers give just, you know, unjustifiable reasons. For example, they'll say to you, because of COVID, this is now the change, you know, and what is it, for example, can an employee do to at least be in a position that he can or she can ask for clarity, for example, especially given the fact that there's remote working as an example? You know, would you still say to your employer, please put that in writing so that I know exactly what the changes are and stuff like that? Is it something that is seeable? Because, as I said, ordinarily you get called into an office and you get told about these changes and you're asked to sign somewhere. How would you think we can mitigate around that, given COVID and the fact that we are not necessarily in the office?
So if I forget to come back to the question you asked me, please bring me back. Please don't forget the question. Like, you just reminded me something that I think is an important step as well, to just speak about. So if an employment contract cannot be deviated from without the consent of both parties that sign the contract, it means that the employer can't also, or should not, just change terms and give them to you to sign. So there must be a process of consultation. In fact, not consultation, a process of negotiation. They need to come to you and say, this is what the employment contract says, and we are bound by this contract. But because of the change in circumstances, we need to introduce new terms to the contract. And therefore, we need to negotiate with you to get your view so that we can agree into new terms. So we'll speak as we go along about the Labor Relations Act. But I just want to introduce at this point that act was promulgated, or it was introduced to give some power and leverage to employees, because ordinarily, as an employee, you don't have the muscles to be fighting big organizations that you enter into contract with. That is why you'll find that in the Labor Relations Act, the balance of the provisions there are really to protect employees against power imbalance. So meaning to protect employees against the power that the employers wield to do things like this, like to change terms and conditions of employment, or to do as they will, contrary to the law of the land. So an employment contract is a fruit of the Labor Relations Act. The Labor Relations Act is a fruit of the Constitution. So if an employer changes terms and conditions of employment unilaterally, not only is it a violation of the Labor Relations Act or your contract, but also of the law of the land. We are at a time in a period where instead of people taking advantage of the COVID situation and therefore plunging people who are needy further into deprivation or poverty or lack or stress, it is important actually, as I said earlier, that we need to approach every matter, including change into terms and conditions, with more sensitivity.
Yeah, no, and thanks for that. And I'm seeing a question from Justine. They're saying, listen, if, for example, the change is as a result of a regulation, does it mean that you still have to consult, or it's just going to kick in?
So if there is a law, and I'll be very surprised to see such law, and I'm talking about regulations in this instance, that directly affect an employment relationship, the employer will then be bound by that regulation. So will the employee. So meaning the change is not introduced by a party to the contract. It is introduced by what we call by operation of the law. So it is very rare to find any law that is passed that set out or that affects or disturbs the sanctity of contract and the agreement between the two parties. But if there is a law or a change, then that change gets introduced by the law and not by a party to the contract. And I think maybe just to take it one step further. So one of the things that we'll talk about later is an issue relating to leave, right? And how leave has to be held. So you'll realize that although there are regulations, those regulations do not necessarily interrupt or disturb the employment contract, but it provides provision for how an employer can deal with a time of distress. So therefore, you can't use that regulation to then say, that is why I'm effecting a change to the employment contract. But you can use the regulation to say, that is why we need to go into the negotiation table to speak about how we can refine the terms and conditions of employment.
No, thanks for that. I guess also it answers why most employers, you will see that they will always say, but these labor laws favor employees. We wish, for example, the Republic of Cape Town, that we want to see a change and allow us to fire and hire as we would. But I think it gives credence to your point earlier that the LRA is drafted in such a way that it is at least taking into account equity and fairness and the power imbalances between employer and employee, which in most instances an employee would not have the mind to deal with this and stuff like that. Now, Khomotso,
can I say something there before you move to the next point? With your leave, please. So if you fire me after this comment, I won't appeal. I promise. I want to appeal against them.
For sure.
One of the things I do, as you know, is I lecture at VETS as well.
Yes.
And when you lecture, it is important that you don't just teach the children the syllabus, but that you impart knowledge. It is important that you impart knowledge that the students will hold on to forever.
Yeah.
So meaning the aim is not to give them information so that they can go and pass, but they can use that information practically. But one of the things that I find as a people, right, both employers and employees alike, that we lack fundamentally and we need to rectify is we don't study. The Labor Relations Act is not a big book, right? Part of the reason why some people face injustice daily, and because of our unequal society, They don't have access to lawyers and to people who can help them to enforce their rights. They find themselves in the periphery, you know, and they find themselves you know, when actually the answers lie in a very small book called the Labor Relations Act or the Basic Conditions of Employment Act. If there is anything I can implore the many people that have joined us here today, with all due respect and with all loving kindness, it's let's take the liberty to make sure that for the number of tweets we read and social posts we follow, we read one page or 2 pages of the act that actually affect our livelihood. Some of the things that we're going to be sharing with you today are actually free and they are open, they are available. And I just want to encourage us to become a reading society. And because if we become a reading society, we become an informed society. And when you're informed, your decision making is precise and efficient. So I just wanted to make that point, because when you teach and people receive information from you, but they also go and study, what happens is, even when they face an exam, they understand that the questions in the exam is 10% of the knowledge they're supposed to have out of the course and the material. So when they move forward from there, they're able to use and apply the knowledge, not only to benefit themselves, but also to benefit others.
100%. I think you've said a mouthful, Khomotso, in relation to that, and let us then empower each other and encourage, for like how we read books. Take once in a while, read a page, as you said, and we can only be empowered through knowledge. And I agree with you, and it's important. Khomotso, we spoke about the imbalance between the power dynamics, employer and employee, and you know, before we even get to the questions, if, for example, an employee is wronged and feel aggrieved by an employer's decision, where can they go? And you know, this ties in with some of the things that will address the legal consequences, what it looks like. But is there a place, or is tweeting just enough, for example, and tagging Tumi and saying, yeah, you know what, these people must be dealt with and stuff?
Well, taking Tumi always works, so I wouldn't take that option out of the way or out of the equation. But the more formal channels that one can use are determined by the nature of the problem. For example, as you'll see later when we speak about leave or about UIF benefits, if there's an issue there, then the right channel to go to will be, or to use, is the Department of Labor. Whereas if it is an enforcement of a right you have in terms of an employment contract, it might be that you first look at your disciplinary code to see what it provides for. It might be provided for there in terms of lodging a grievance, and you can lodge a grievance with your HR or with your direct manager. Or alternatively, if it is not provided for in terms of internal policies, you can approach the CCMA or a bargaining council. If the employer you work for falls within a sector that is regulated in terms of a bargaining council, then you can go to the bargaining council, or else you can go to the CCMA. So I think what I'm trying to say is, whenever you have a problem, you need to ask yourself, what is the nature of the problem? And if the problem has to do with the department, then it is a department issue before it becomes a legal issue. And if it is an enforcement of your right, then you need to first look internally, because we must always try and exhaust internal remedies first before we go to the external parties. And can I also just pause at this point and mention this? I have a dream. Okay, I'm not Martin Luther King, but you know.
I was about to say, check yourself.
I have
I
have a dream that one of the things that we are reflecting about during this COVID times, during these difficult times, is to go back to employment spaces where there is no tension between the employees and management. I think that is very important. Because if there is no tension between employees and management, it means that just like go high, go family, if there are issues, we can talk about them first. You know, we can show each other the way before we create. We are in a system where certain things that are not even supposed to be disputes become disputes, and they create tension. Because whatever course of action, legal action you take as an employer or as an employee, if it is not preceded by sitting down in an attempt to try and find a common ground, it will always strain employment relationship. And in the long term or in the long run, what you find is you find a company that is functioning, but with people who are not devoted to it.
Yeah.
Because they don't have their buy-in. They don't buy into the vision. It is almost like staying in the same house with someone who abuses you. You're always on the lookout, and you never feel at home. So I think that is very important. If we can, I know some of the people listening here are probably management representatives, some employees. We somehow need to find a way, if we can help it, that we can rebuild the employment relationship. I mean, remember that first day when you signed that contract, the smile and the handshakes, and why can't we go back there?
Yeah, and I think that's a good point. And I like, while our viewers are listening and watching this, to ask an important thing. You are sitting, you think you have more time, for example, and you are tweeting away or Facebooking away, and when I started, I spoke about how these dynamics are different. I'm no longer in the office. I probably think that I have more time on my hand, and I say all these things. How do employers, for example, perceive this type of conduct on social media at the end of the day? And does that employment relationship, although you working at home, survive the employee's conduct on social media and stuff like that? And what are the tips that you could give to an employee who normally would want to tweet away and forget that they're still employed by an employer? So thanks for your question, Teo. I think it's a quite important one. And we're seeing something on Disaster Management Act, where is it or can it be used to forgo consensus to retrenchment? And we'll address that, because I think this is one of the questions that was asked, and we'll have a Q&A there. Ms. Mello, definitely this will be saved. It will be on Khomotso's IG, on the highlights. It will also be on my IGTV, and we'll tweet the link, and you can share it as much as you want. We will also house it in our respective website as they become available and stuff like that, so that you can always refer to it. But please just address us on employee behavior, especially during COVID, where you think you have time. Instead of you being in a meeting or you have a deadline, you take something, you tweet, and sometimes, say crazy things on Twitter.
So I'm going to start with employer behavior first, because it is not only employees that have to watch their behavior, but it is employers. And often employers are represented by senior management. So it is important that we understand, both as employers and employees, that we have the right to free speech and we have the right to privacy, but every right has a responsibility, has an accompanying responsibility. So we need to act responsibly at all times. So the employer has the obligation to make sure that whatever information they dispense as management, it's information that is known to the employees, but also that they know and must understand must be palatable to the employees. If they know or ought to have known that it might not be palatable to the employees, it is important that you sensitize your employees first. Because if I'm an employee of an organization and I go on social media and I find things there that are not palatable to me, again, it goes back to what we said, and it creates tension. So talking about social media, so this is one of the topics that I've had the privilege to talk about since the past 4 years. And I'm going to just talk about 3 things, although there are many. But one is, it is important that every organization has a social media policy. And why I say that it is because whatever the social media law is, it is important that you have a policy that is able to address the unique challenges of your organization, because organizations are not the same. So that is very important. So if you don't have a social media policy, you need to get in touch with a lawyer. I didn't say me, but you need to get in touch with a lawyer to help you with that, because we are moving into a time now, as we can see, that things are changing and a lot of things are going to become digital and so on. Okay. The second thing I want to speak about is the right to privacy. So some of you who have been working for a long time will remember the times when whatever you do, it's not affecting anyone else, right? But the advent and the increase of social media has blurred that distinction. But we are not very well as well. So, the advent of social media has changed and blurred that distinction, because we do work now on our WhatsApp, and WhatsApp, remember, it's also social media. On our Gmail is also social media, and other platforms. And we don't work until 4, we work until later, you know. Yeah. But also, what the advent of social media has done is that if right now I tweet something, what people do is they not only will they search who I am, if that thing is untoward, they also search who I work for, and the name of the company then get involved. So therefore, that is what makes it misconduct, you know. So meaning, whenever I tweet or I do something or I post anything on social media, I need to be mindful of the fact that the privacy that I have is very limited. And anything that may taint the reputation of my employer, I am accountable for. And we have unfortunately seen many cases in our country recently where people have been dismissed for what we call social media misconduct. So it is very important, if I can give 2 tips. Never allow yourself to live under the illusion anymore that your privacy is your privacy. That whatever you're tweeting is your private account in the comfort of your home. Because whatever you say, if it is out of 10, if it is something you would not say when you're at work, please don't say it. Because there is no one who has ever said anything racist or anything wrong that has not been attached to an organization. That is just how it is. So that is the first tip. The second tip is, if you want to post something and you feel a tingle behind your ear, please don't. Or if you had 1 or 2 glasses of wine, please don't. Think about it and wait until after you've had the sermon on Sunday. You might not retweet or repost. So it's very important.
Yeah, no, and thanks for that. And I agree. And I could tell you so many stories about social media and the trouble with some of us who probably have that tingle and still go ahead and do it. But I totally agree. But what we also find, and so thanks for your questions, where I have a disclaimer. I tweet in my own personal capacity. My tweets don't represent that of an employee, of my employer rather. And therefore, you know, does that still give one carte blanche to basically still go ahead and say all those things? Or that disclaimer really just doesn't work, you know, or rather it would be interpreted differently.
I see people are laughing here. Thank you. It's encouraging. Stumza, Botlale, Claire, thank you so much. Please keep it. That's for me as well, Stumzo. So sometimes what we need to do is, remember what we started with. We said, perhaps we are facing a time now where for the first time we are asked or requested or required even to be human first before we are an employer or employee, but to be human, to try and say, what is the most humane thing to do at this point? So if you are in the shoes of an employer, the answer to your question is very different to when you're in the shoes of an employee. If you are an employer, you work so hard and you invest so much capital and time and resources in trying to build an institution. And what you don't want is, you don't want an institution to be dragged through the mud because of one issue or something which someone did in their private capacity. So therefore, if you're an employee, you also don't want to be so constrained that you can't exercise your private, you can't live your private life. But as we said, for every right, there is a responsibility. So in exercising your right, please be responsible. Disclaimers don't work. What is important is you can still make a point, right, about something without being demeaning or without being degrading. So therefore, we need to learn to use language that says, I am responsible. I think that is very important, particularly if we appreciate the fact that we owe a certain duty to the people who give us an opportunity to work for them or with them. Even if you work for yourself or you have your own company, for you to get deals, I can tell you now, there are companies that are employed before you come into the table to look into your social media conduct, because they don't want their brand to be associated with certain negative issues or negative connotations. But I mean, on the light side of life, look, if you have a 6-pack or you have a 1-pack and you are good about it, you are not ashamed about it, you can put that picture there. As long as whatever you say is a caption, right?
Yeah.
It's not disparaging or it's not. So it doesn't mean we can't enjoy life as we know it. It just means that every time you go and you post or you share information, just make sure that you have at the back of your mind the responsibility that you owe as a responsible citizen.
Yeah, thanks for that. So do share your summer bodies and your runs and all of that. But remember, those captions are important. So I just wanted to emphasize those disclaimers don't work. Be responsible when you're posting on social media, and also go and read your social media policy where you work. Ask them, what is the policy? What does it say? And see if you are operating within those confines. And I mean, I'm a proponent of free speech and all of that. And I think it's always going to be a very interesting balancing exercise of, do we let people speak and share their views, but at the same time, while respecting the employer and employee relationship? So it's a fine line, and not many people are able to master that. But I think we are not saying, Khomotso and I, that go and just shut up and no longer tweet. Think about it. Say what it means. I mean, right now we're seeing so many issues related to race or otherwise. You don't want to get into that discussion and still fuel that type of thing. But you are able to say, listen, racism definitely must fall. We want to be in a country where, we are not being discriminated against and stuff. Your employer can come and say, but that's insane, take that down, because that probably is one of their founding values. That's probably one of their missions and objectives while working and operating in South Africa or elsewhere for that matter. So it is really important to always know what is required. I am mindful of the time, and I know that there will be various questions, and we can talk, until 2 o'clock, and we're not going to do that because we know that data is an important thing for our people, and they have other things. I'd like for us to straight go into the questions that people have posed, from a practical perspective, and they will talk to some of the legal consequences, the responsibilities and stuff. So instead of us addressing it theoretically, let's just now talk about these questions that have come up that are prevalent on social media or otherwise, and see how can we assist people, give them tips insofar as that it's concerned. Odio is asking, can one refuse to go to work if you feel it's not safe for you to do so, but yet you are still able to carry out your daily duties? I think we probably need some context there. If you feel that it's not safe for you to do so, what would make it unsafe? Do you think you're probably going to catch COVID-19 there, or you'll probably be in a taxi and get stopped? Or just provide us a bit of context so that we can at least make it specific to that, and we'll talk about duties of the employer providing a safe working environment and some of the measures that they need to take. Okay, welcome back, Khomotso. I don't know what happened there, you just went down.
Thank you.
But welcome. So that's one. We are not going to just proceed on that, but let's just see. Madonsela is asking you, do you believe the regulatory body or Department of Labor needs to be strengthened to stop things like companies who take money and don't contribute to UIF or fail to comply with the LRA? I think this is a pertinent question that keeps coming up, although it's coming up differently. But maybe let's just get in. One of the first questions I think that got more retweets and stuff was, is it legal for companies to cut hours and salaries during a lockdown? And thanks for your question, Madonsela.
Thank you, Tim. And I think I'll come back to the question. I just want to answer the two questions which were posed here. So we spoke about being humane in during these times and trying to get into a process where we work together with the employer.
Yeah.
It is no one actually knows the answer, Odi, to whether it is safe to go to work or not. And if you say to an employee it is not safe, at least also be responsible enough to say why it is not safe and try and find solutions together with them to go to work. If you say it is not safe because they have not done the homework that are supposed to do as required by the regulations to make the workspace safe for you to go back, then you can raise that as an issue. It's legitimate. And if that is the case, they can't force you to. If it is because you use public transport and you have seen that taxis, even though they said they should not be filled, they continue to be filled, or because you've got a pre-existing condition, all those are reasons that you can give that are sensible and responsible for the employer to consider. The employer must consider them and make plans either to provide transportation for you or to provide means to get to work that will not make sure that you are you face the risks of contracting the disease. So there might be many other things. And I think what I'm trying to say is, as an employer, I'm at a point now where it is no longer business as usual. I need to listen to the employees and what they say, and to the extent that I can help them to work from home, I need to do so. But if the work they have to do requires them to come to the office, we need to be sensible enough as well as employees to say, we're going to work with you without sacrificing our livelihoods or without sacrificing our health, but to make sure that we are safe. And therefore, as we offer a problem to Sakan, also offer a solution as to what could be done to make you comfortable. And,
thanks for that.
The other question you asked me was about reduction of salary.
Yes.
If I'm correct.
Yes.
I think,
is it legal for companies to cut salaries during lockdown?
So the simple answer is yes, but it is more nuanced than that. Remember, as we started with an employment contract, an employer can't change an important term like remuneration without your consent. So they can legally, but it must be with your consent. So let me leave it there, because there are other questions which will also feed into this first question that was asked. So the simple answer is it can only be done with your consent. It can't be done unilaterally.
And what would be an example where an employer would propose a cutting down of salaries as an example, or, saying, because of COVID and what we're looking at, you can't now come and work 8 to 4, but would rather have you work between 8 and 1, and then the rest of the amount we are not going to be able to pay and stuff like that. Is it something that is an option for an employer? And obviously it's going to affect the employee's pocket. What then in those circumstances? And is there recourse? Is it an unfair thing, or is it something that at least it's also legislated and people just don't know about it?
So the terms of employment are governed by the Basic Conditions of Employment Act and the Contract of Employment. So during situations like this, or during times when companies are not doing well for whatever reason, this time it will be COVID-19. If in terms of the collective agreement concluded at the bargaining council, short time is provided for, then the employer, on the basis of that agreement, can enforce short time during these times. Or if it is provided for in terms of the employment contract, then the employer can say, well, this is the time to call on that loss because of the situation, right? Because it has been agreed. If it is not provided for in terms of the collective agreement or the employment contract, it can only be done by agreement. The employer can come to the employees and say, look, these are our books, we're doing bad because of the situation, and as a result, we may have to consider retrenchment. But short of retrenchment, we want you to agree to short time. So that instead of working full hours, you work half hours, and then this will also speak to your remuneration. Then the employees can agree. But if you don't agree, then the only other legal entitlement the employer has is to undergo a retrenchment process. But they can't do it on their own without your consent.
100%. Thanks for that, Khomotso. And we are going to talk about what is a typical retrenchment and what it looks like. The second question also is, what are the consequences of companies failing to pay the full amount to their staff, full amount of UIF to their staff? That's what comes up about as a question. And I think this is premised on the basis that we've been told by government and regulators that there's UIF, we need to apply, the Solidarity Fund has allocated certain amounts there and stuff like that. So what really are those consequences if a company fails to pay UIF to their staff?
So that is illegal. And you can report the employer to the Department of Labor, and they will appoint, hopefully, an inspector to go to the company to find out why they did not pay, because that is a crime. So it is important to understand this. UIF, particularly the temporary relief one that has been made available now for COVID situations is to help employers who can't pay salaries during these times. And the employers who have been paid that money, because ordinarily, as you know, if someone claims UIF, they themselves apply to UIF, to the department for UIF, but under the circumstances to fast track and to remove the administrative burden from the department, they said employers must apply on behalf of the employees. But what the department has done is on its website, it puts a list of the companies that have been paid UIF money. So you can go there and check if your company has been paid UIF money. And if they have been paid and they didn't pay you the whole amount, you then report them to the Department of Labor. And hopefully, so one of the issues that we have is the enforcement has been slow. So people, as you can understand, I mean, people are stretched now. So maybe the department needs to look to having more inspectors so that when people go there and query, because often than not, if they don't get the full amount, they need someone to attend to their query immediately. So therefore, they need more inspectors to be able to go to companies that do not comply, to make sure that they can force them to comply and impose those penalties in terms of the regulations.
Thanks for that, Khomotso. So in essence, you and if you look at also your employment contract and your payslip, there's provision that X amount of it goes to UIF, right? And in these type of circumstances, you are hoping that's what's going to happen and stuff. But Spoo is asking an important question in relation to the answer that you initially have given insofar as cutting off salaries during lockdown. He says, would your answer be the same in the event where employees are not working at all, and then you still find, being told that regardless of you not working and rendering services, we most likely going to cut your salary?
So the answer doesn't change. The employer can't change the term and condition of employment without your consent. So if let's say, for example, some companies, because they were not providing essential service, they were forced to close down or not to operate during those times. The employer had two options. One is to approach you at that point in time and say, look, because we are forced to close down, we ask you to take leave. You need to take annual leave. If you don't have leave credit, they can give you special leave, which is paid. If they can't pay you because they don't have money, you then can agree to take unpaid leave. But they have to approach you and you have to agree. If that fails, they can say to you, okay, look, we won't be able to pay you a salary because you can't work from home, because of your inability to work from home at all. So as a result, we're going to lay you off during this time. If that is by agreement, then that can happen. If it is not by agreement, then as I said, the only other legal avenue they have is then the retrenchment process. But the company, I mean, as we speak right now, I can tell you there are many companies who had employees who stayed at home that couldn't render a service, right? And instead of looking into these options, they then said to them, okay, fine, we are going to submit applications on your behalf to you for that relief fund. And that is how they then ameliorated the situation.
No, definitely, and thanks for that. Tseho as always is asking about employee misconduct, and I think it's an important one. While we're talking about retrenchment and short time and that, you find people, for example, saying, I can't tender my service to my employer, but with the advent of social media, all of a sudden, I'm taking myself, or Khomotso takes me at your house or something like that, and tomorrow I then say, I get to medical because I fear COVID and stuff. Would that constitute misconduct? And could an employer invoke its disciplinary processes to deal with such an employee?
So they can allege misconduct. Whether that will be able to be proven or not is a different story. But I keep going back to where I started, Tumi, that we are all trying to cope under the circumstances, under an unfamiliar environment. So therefore, we need to be loath at calling misconduct and so on. But also at the same time, as employees, these are the times when we need to show our commitment to employer more than we ever have. Because in order to inquire into the good graces of the people who take decisions that impact us, we also need to show them something. We need to show them commitment. So I think if anyone does anything that brings the reputation of the organization into disrepute, or anything that violates the policies and processes of the employer can take action against them, even if they're at work. For example, if you're on a Zoom call, right, and there you are drinking your wine or drinking beer on a Zoom call, a work Zoom call, they can take action against you. So therefore, these are some of the things that I spoke about being responsible as people. But also at the same time, because policies are not drafted to cater for working from home, most of them, we need to be loath or slow in taking action.
Yeah. No, definitely, Khomotso. And I mean, most of these questions are dealing with UIF. You know, someone is asking, how does it work? I think in those instances, and without, you know, hammering the points, you'd have to look at the Department of Labor. In fact, they do have on their website a detailed schematic view of what is UIF, who can apply, what it looks like, and stuff like that. Modise, we see your question, and we will address it. I just want to see if we are not repeating these things. Someone asked, is it legal for a company to say that they will not pay the UIF money claimed and rather give you guys leave in December? So you are not getting paid, but the employer says, listen, in December, when COVID hopefully would have been a thing of the past, you will then get leave. Is it something that could be considered legal?
It's not legal for the company to claim money from government and keep it and give you leave.
Yeah.
So when the company applies to claim the money, they apply to claim it for you, for your benefit. So either the company can decide to put you on paid leave at home and say, we'll make up that money in December, or you're supposed to take leave, you're going to be required to work. But they can't keep the UIF money.
100%.
Or they shouldn't.
Yeah.
And if they do, it goes back to the earlier answer. They have to, the employee must report this matter to the department, because then they're 100%. Taking money out of the department that could go to other people who are needy.
This is true, definitely. And what we're also seeing in terms of COVID, and I know we have 5 minutes and we're about to do our closing remarks, is, you know, what happens if an employee needs to stay at home, look after the children because schools are closed and now they're about to open and there's nobody working for them? Can an employer insist that they take annual leave to do so? And also, what happens if someone really starts running into negative leave because, you know, you are now at home, you're exhausting your leave days? In those circumstances, what would probably be advisable or practical, or what is it that people who are watching and listening can heed the advice there?
Well, three things. One is, one is, if you have to attend to a child full time and you can't work, then you can request your employer to give you leave. If the employer can't give you leave, then you have to find other ways to agree with them about times and so on and deliverables. But again, it goes back to the second point, which is you need to find a way to agree with your employer about how you make that situation work. Thirdly, and importantly, as employers, and as I said, I assume there are people here who represent employers. We need to understand that times are uncertain, times are unimaginable, and therefore we need to be relaxed in terms of what we expect of our workers. And therefore we need to be willing to make sure that we can accommodate. It's the principle of accommodation, both from the employee 100%. Side and also from the employer. So if it means that you have a partner, for example, and you can take shifts, one can attend to the child in the morning and one in the afternoon, then that is the arrangement that you can put forward to the employer to consider.
100%. Thanks, Khomotso. And I think that's very helpful because, you know, we need to be sensitive to the different circumstances of our employees. And I think employees should not be shy to tell their employer what the difficulties are and what it means and what those particular impacts are. On retrenchment, and just before we conclude, someone is asking, is there recourse to retrenched employees once they have agreed of certain amounts or severance packages when an employer suddenly reneges on that particular agreement? This is from Modise. I don't know if you can see that question. I think it's the last question.
I can see the question from Modise. So if there is an agreement for voluntary retrenchment, or if the process has been done and the employer fails to pay, the employees can take that employer to court, certainly. But what and that process takes long, unfortunately.
Hey guys, sorry for an abrupt end to that. I think normally an IG session would probably be an hour max at the very least, so that's why I'd probably kicked us out. I do apologize for that, and thanks to everyone else who's joining in again. I'm just waiting for Khomotso to join shortly, and we will just basically tie up, finish up with closing remarks. So please just bear with us. And once again, I apologize for that abrupt ending of the initial session. So this is not going to be another hour. It's literally going to be short, just to tie up and summarize what we spoke about, and what options are available to employees in these COVID times as well. So bear with me in that regard. Thanks for your understanding. I appreciate it. People are coming in that were initially on the call. Some new people are also joining. Sorry about that. Someone wants to be in my live video. I'm just, there you go. Commenting on my hairdo. I can't go to the barber, so give me a break. So just bear with me. Mr. Makapane, welcome back. Sorry about that abrupt ending. What I've now figured out is you can only do this thing for an hour, and anything else Instagram will cut it. And I also think we could be sitting on unlimited Wi-Fi, but it's only a little fair in terms of what they could take. But we're just talking about retrenchments, and where there's no agreement between an employer and employee on severance pay, what would be the recourse for an employee there?
So if there is no agreement, the employer then can't. So the retrenchment process can't end until the parties have reached an agreement on the amount of severance pay. But as you know, the standard from the Act or from the BCA, the Basic Conditions of Employment Act, is 1 week pay every completed year of service. But the law says the parties can agree on a better, not less, a better severance package. And if after you have agreed, the employer fails to pay that money, you can certainly take them to court. But for expediency, you can just approach a lawyer to write to them a letter of demand, because often they do respond to a letter of demand before you go to court, so that at least they can pay in good time. Yeah.
100%. And thanks for that, Khomotso. I think, we also don't want to go again for another hour where we explore these things and looking at all of that. Hey, you are welcome. Okay. Hey, technology. You press something and suddenly something else appears. But Khomotso, thank you. I think we really touched on what is the employment relationship. We spoke about employee misconduct and the fact that Facebook, Instagram could get you into trouble, especially if you find yourself misconducting yourself and dragging your employer as a result of that. Siwa, I see you. Hello. Someone says, let's hurry up. Definitely, we are about to conclude. And more importantly, we spoke about the UIF and the cutting of salaries, and when it's legal, when it's not legal. And we ask that you go again, watch the IG that we'll share shortly, and play it forward back and see what we said in relation to that. And the last thing is, remember to read the BC EA, the LRA. More importantly, also look at your social media policy. We still want to see your running tags. We want to see that summer body and all of those things. Those are what you can do, and would not be bringing your employer into disrepute. But be mindful of what you're posting. As part of your parting shot, Mr. Makapane, what is it that you could say to people during COVID-19 in general, legal or otherwise, and for them to at least keep safe in these trying times?
What I'm going to say is probably not expected, but I'm going to say it because it's very close to my heart. We need to get to a point where we tolerate one another again. We need to get to a point where, as a people, we operate in the spirit of Ubuntu. We need to love and care for one another. And in that way, we won't always be looking at our backs to see who has our back and who can stab us and so on. And secondly, as a parting shot to say, I cannot emphasize more than is necessary the importance of making sure that we are not only informed as people. Twitter and Instagram and other social media will give us information, but we need to have knowledge. Someone said many years ago that knowledge is power. That is very important. Because if we are knowledgeable, even when we seek help, we do so from a solid base. And there are certain things that we can prevent happening to us, which are necessary. And then finally, just to say to everyone, thank you for tuning in and for listening to us. It is not that we know everything. It is just the little we know to share, and we appreciate your time and your data. And if you know someone whom this may help, please do reach out and share. It might help someone. So thank you kindly, and keep well, keep safe. But as I said, let's go back to being human again. Let's be human, because if we start by being human, other things will naturally sort themselves out.
100%. No, thank you, Khomotso. I think you've said a mouthful, and we don't want to hammer that point. Thank you very much to everyone who's tuned in. I will be making those announcements as to who is going to be our next guest next week, Thursday. It may be this coming Thursday or next week, but it's really dependent on you sending questions, you saying what is it that you want to see me discussing. It's for me to just speak to people and nudge and stuff like that. And there may well be trial and error. I mean, one example is where we just cut, and we didn't know what's happened. These things are bound to happen, and thank you for bearing with us. More importantly, coming back and closing out this particular call. So thank you to each and every one of you. We really appreciate it. Mr. Makapane, I really appreciate your time and, taking it and sharing this type of knowledge with the viewers. Please follow Khomotso both on Twitter and Instagram. You would have seen in the poster that I've pinned, and, have conversations. He is a good guy after all. And by the way, he also runs Comrades. He's insane. He once invited me to a gym. I don't think he still remembers. And one session, and that was the end of me for a week. And that's why now I've reverted to running and not weightlifting and all those things that he has done. But yeah, thank you once again, Mr. Makapane, and keep well.
Thank you for inviting me to me. And again, thank you for everyone, and have a good evening.
Cheers, brother.
All right. Cheers, buddy.